But now we turn our attention to why Ross Ulbricht's charges should be dropped. This from McFlugel.com, who writes, "Those following the Ross Ulbricht case understand that this is an attempt by the federal government to usher in the passage of terrible laws curbing free speech and internet freedom by holding website owners responsible for the content posted by third parties." Paul Joseph Watson of Infowars.com writes, "Although media coverage surrounding the case has almost exclusively focused on the accusation that Silk Road was a haven for criminals and drug dealers, the much larger issue of how the government is exploiting the case to set dangerous precedent for laws which would crush basic internet and financial freedom has been overlooked. The fact remains that Ulbricht is guilty for none of the charges levied against him, only for allegedly running a website on which such activities were alleged to have taken place. As the Free Ross Ulbricht website notes, quote, "If Ulbricht is convicted, it opens the door for the censure and erosion of a free internet. Under present law, website hosts are not responsible in civil cases for illegal actions on their sites. This case could set precedent for criminal liability for web hosts." In an interview with Julia Taranskaya, Ulbricht's mother, Lynn Ulbricht, explains why the case poses the biggest threat to the future of internet since SOPA and PIPA. Quote, "This case will pave the way for new laws and new interpretations of law," said Ulbricht, adding that Ross Ulbricht's attorney, Joshua Drattle, emphasized the fact that the government often uses high-profile cases to enact draconian legislation. Court rulings set precedents for cases in the future, which is why judges write opinions to explain their reasoning. Future cases take these opinions into account so that judges have something to work with when presented with a new or nuanced case. This is how common law, the basis for law, developed out of Britain, and then to its colonies is developed. To overturn a precedent, especially one that has been confirmed multiple times over, would require significant proof against its prima facie validity. It would therefore be improper to rule against a defendant in a case where precedent is fairly clear. Last week, I attended my first Liberty on the Rocks meetup in Philadelphia, where the guest speaker was Maggie McNeil of the Honest Cartesian. She talked about how the government uses propaganda to manipulate the discourse about prostitution, making it easier to pass harsh laws that favor control. On one case she mentioned was a law passed in the state of Washington, which claimed to take aim at child prostitution, stating, quote, "A person commits the offense of advertising commercial sexual abuse of a minor if he or she knowingly sells or offers to sell an advertisement that would appear to a reasonable person to be for the purpose of engaging what would be commercial sex abuse of a minor, if occurring in this state." Nearly all of us are against the sexual abuse of children. So why would we be against a law that prosecutes people who aid in the sick desires of active pedophiles? The law, on its face, may seem okay, until you see who could be prosecuted under it. In a prosecution under this statute, it is not a defense that the defendant did not know the age of the minor depicted in the advertisement. It is a defense which the defendant must prove beyond a preponderance of the evidence that at the time of the offense the defendant made a reasonable bona fide attempt to ascertain the true age of the minor appearing in the advertisement by requiring, prior to publication of the advertisement, production of a driver's license, marriage license, birth certificate, or other governmental or educational identification card or paper of the minor depicted in the advertisement, and did not rely solely on oral or written allegations of the minor's age or of the apparent age of the minor. The law was written vaguely enough so that not only those people who provide direct advertising services would find themselves in hot water over posted material, but also services that simply provide users access to information across the internet. It wouldn't be too far of a stretch to imagine to see Google prosecuted under this law because someone used the site to search for one of these advertisements. The law could potentially destroy the internet. We continue right along with the story from McFloogle.com, where author Rollo McFloogle writes about why Ross Ulbricht's case on the Silk Road and Andrew's case should be dropped, because there's legal precedent that says that's exactly what should happen. We're talking about why the rule in Washington explains that Google could be targeted just because some user searches for some inappropriate photo. Well, surely that doesn't make any sense. So the precedent has been set that admins or controllers of websites can't be held personally responsible for what the users of the site are doing. So as such, Backstage.com, the Internet Archive, and the Electronic Frontier Foundation, or EFF, joined together to fight the law in Backpage.com v. McKenna et al. In 2012. Backpage.com had a section of their website that hosted adult classified ads, which sometimes featured advertisements for underage children, despite Backpage.com's policy and efforts to block them. The Internet Archive was concerned that as part of its online repository, it could cache a sex ad and then be liable under this new law. They charged that it violated, along with the Commerce Clause and First, Fifth, and 14th Amendments, Section 230 of the Communications Decency Act, which states, quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." Well, doesn't that make it pretty clear that Ross Ulbricht shouldn't be held liable for this Silk Road business? Presiding federal judge Ricardo Martinez ruled that a permanent injunction be granted in favor of the plaintiff, blocking the bill on the grounds that it was unconstitutional and a violation of federal law. The parallels to the case of Ross Ulbricht are strong and undeniable. It would make perfect sense to apply this ruling to Ross. Backpage.com and Internet Archive have argued that compliance to the new law would require them to take unfair, costly measures. The judge agreed in his opinion. Quote, "A credible threat of prosecution exists when a challenged law is aimed directly at plaintiffs who, if their interpretation of the statute is correct, will have to take significant and costly compliance measures or risk criminal prosecution. Does ignorance or the lack of monitoring bring blame to the host of the online content?" Judge Martinez says no, given the nature of the Internet Archive service and the fact that it currently does not monitor the majority of the content it provides through its Wayback Machine. A criminal statute that imposed strict liability on the Internet Archive would be costly indeed. Compliance with the law would require the owners of the Internet service to prevent any and all illicit activities from being posted through them. Well, good luck with that. We don't even know how many laws are on the books. Even though the service itself is perfectly legal on its own, to remain compliant with the new law would more or less require the service to be shut down, since it would be nearly impossible to achieve the goal of zero illicit content. But what if the owners of the service did not even try to block the content? Surely their inaction would constitute illegal action, right? Judge Martinez makes it clear that this is not the case. Quote, "The message to website operators is clear. If you don't encourage illegal content or design your website to require users to input illegal content, you will be immune. Well, can't get more clear than that. He later reiterates this point, quote, "Second, the bill is inconsistent with Section 230 because it criminalizes the knowing publication, dissemination, or display of specified content. In doing so, it creates an incentive for online service providers not to monitor the content that passes through its channels." This was precisely the situation that forced the initial plaintiffs to act on the remedy, the Communications Decency Act. Judge Martinez then goes on to explain how the bill violated the Commerce Clause and the First, Fifth, and 14th Amendments, all of which can be applied to Ross Ulbricht's case as well. The conclusion is clear. The government has a legal obligation to allow Ross Ulbricht to enjoy immunity from prosecution for simply knowing that illegal activity was happening on, allegedly, his website. This was confirmed in a case even when the apparent goal of the struck-down law was to prevent people from having sex with children. The unfortunate reality is that it is all but certain that the prosecutors in Ross Ulbricht's case understand this, but are willing to violate their own laws anyway to push their own agenda. You can read Ross's story over at freeross.org. That's where you can donate to help in his defense fund. He needs all the help he can get, as this is the case of our lifetimes. If you don't think that's true, I mean, I challenge you to call in with a bigger case, something that's going to have more important ramifications for the internet, for freedom of choice, for control over our own bodies. I mean, the implications of this case are far-reaching and not to be understated. But it's not going away, remember. Just because Ross Ulbricht or Andrew are in jail doesn't mean that people are going to stop acting free on the internet. Nerds, geeks, and other sorts of internet lovers will preserve internet freedom. It's just going to happen. It can't be stopped because there are too many of us. And it's unknown what we can do. Now, Reason.com reports on this subject just recently as Google Dark. In April, an anonymous individual launched a search engine called Grams that caters to contraband needs. Sound familiar? Well, for black market goods, many people turn to hard-to-access corners of the internet, which generally haven't been conducive to browsing, writes Sinan Evans at Reason.com. In April, however, an anonymous individual launched a search engine called Grams that caters to contraband needs. Known only as Grams Admin, the engine's creator explained to Wired, quote, "I noticed on the forums and Reddit people were constantly asking where to get product X and which market had product X, or who had the best product X and was reliable and not a scam. I wanted to make it easy for people to find things they wanted on the darknet and figure out who was a trustworthy vendor. So Grams spent 2 weeks building Grams, which looks a lot like Google, down to the primary color scheme and feeling lucky button. In the second beta version, Grams had an average time of 1 second for a search to load, which is generally considered fast for the web's back alleys. Grams shows results from 8 different marketplaces, such as Silk Road 2, Agora, and Blank Bank. For those who want to give it a whirl, the address is listed at Reason.com. It's so important to remember that this stuff is not going away, and that just because you shut down one website, well, that often gives the incentive for more to appear.